Friends, despite loud protest, media debates, and a petition filed in the Supreme Court of India, the President of India, Mrs. Draupadi Murmu, gave her assent on 5th April 2025 to the Waqf Amendment Act. The law was published in Extraordinary Gazette of India, making it active and enforceable nationwide. The Waqf Amendment Act 2025 has stirred significant debate among landowners and legal experts alike. What is the Waqf Amendment Act 2025 all about, my friends? This amendment brings major changes to Waqf Act of 1995 with a focus on land ownership verification, government land protection, digital registration, tribal and heritage site safeguards, transparency and accountability of Waqf boards. There are top 5 changes you must know about. Number 1, the Waqf can't be created without ownership. The Act clearly says no one can declare a property as Waqf unless they are the legal owner with a valid right to transfer it. This ends the practice of oral Waqf or verbal claim on land without proper title. Number 2, digital portal is mandatory. All Waqf properties, old and new, must be listed on a central portal with maps and boundaries, name of Waqif dedicator, user, occupier, income, cases pending, etc. should also be informed. Deadline for doing this is 6 months with one-time 6-month extension possible. Number 3, government, tribal and heritage land protected. Government land can no longer be marked as Waqf. No Waqf allowed on scheduled tribes land. Protected monuments like forts or ancient sites are off the limits. Any such declaration will now be null and void. Number 4, High Court appeals now allowed. Earlier, Waqf Tribunal had the final say. Now, citizens, institutions and even state agencies can appeal to the High Court within 90 days. This empowers those wrongly affected by past Waqf declarations. Number 5, new rules for Waqf boards. Monthly meetings mandatory. Must include women, non-Muslims and community representatives from Sunni, Shia, Bohra and Aga Khani. Audit required if annual income is greater than 1 lakh rupees. Unregistered Waqf can't file court cases after 6 months. Why this law was needed, my friends? Waqf boards reportedly control over 5 lakh acres of land, much of it disputed or unverified. Across India, cases emerged where public roads, schools, government buildings were suddenly claimed as Waqf. Citizens were locked in long legal fights. No centralized digital record existed. Therefore, this law intends to clean up the system, protect public interest, and bring accountability. The twist is, my friends, in all above, there is one twist, and that is the challenge in the form of writ filed in Supreme Court, which is not yet started, is still pending, whereas the law is now active but not unchallenged. Parties like AIMIM and others have filed petitions in Supreme Court arguing it violates religious freedoms, it targets Muslim trust unfairly, it interferes with minority rights under Article 29 and 30. As of now, no stay has been granted, no interim relief ordered. The act is in full legal force. So yes, the Supreme Court may intervene, but until it does, the law stands, my friends. On this, there is a sharp divide among public reactions. Supporters call it a bold move to end land encroachment and ensure transparency. On the other hand, critics say it is a political attack on Waqf autonomy and minority rights. Why it matters to you? If you are a landowner, government official, religious trust member, legal journalist or RTI activist, this law should change how land is governed, claimed and contested across India. My friends, will Supreme Court be able to stop it, or this will create a new chapter in Indian history? Do share your comments, and if you like this, do share it with your friends. And so far, if you have not subscribed to KanoonPlus channel, my friends, do subscribe. Till then, thanks and goodbye.